Thank you.
Oh, thank you. I appreciate
Some of
that.
my stuff, but then I got moved down more, so.
Right.
What do you have, Mr.
Thank you, Ms. Rothschild. Yeah, we can introduce the issue off the record and then, as necessary, put it on the flags. Yesterday at 6:33 p.m., all parties received an email from the department advising that additional data has been posted on the Mass DEP website concerning air sampling conducted in the area of the proposed facility. The email indicated that the department received the data on Monday evening. The PDF document that was available on the department's website consists of 759 pages. And just doing a word search for the word benzene within that document yielded 2,401 hits. This is a screenshot of that. Needless to say, it was impossible for the petitioners to review that information in the 12, 14 hours or so we had between receiving the information and this moment. So without casting any aspersions as to the timing of it, we simply need time to review the information that was provided and don't want to be precluded from commenting on it, offering supplemental testimony about it if necessary. We just don't know what's contained within the document yet. And certainly my experts, Dr. Nordgaard and Dr. Phillips, this is squarely within the purview of their testimony to review the air sampling results.
Do you have a copy of the cover email you received?
I have it electronically. I didn't print out a copy of the cover email.
Who is it from?
It is from Miss Lauren Karam.
And this was, identifies that it was posted to the DEP website?
I'll read the whole thing, it's very short. Council, please be advised that additional data has been posted on the Mass DEP website, https://www.mass.gov/doc/revised alpha analytical laboratory reports, May 2019. The department received this data on Monday evening. Thank you, Lauren M. Karam.
But that was not filed with OADR, so that this information is not part of the record in this.
Correct, and we would request that it be added to the record of this proceeding as well.
Thank you.
This is data that my understanding came to the department.
It's from Alpha Analytics. It was data that we didn't know they had, and recently employees at DEP management asked for any additional data that analytics may have.
Which DEP management and when did they ask for?
I don't know. I don't know. It was asked for within the last week or so, I believe, last couple of weeks.
Mr. Cushing, were you involved in that transaction?
No, ma'am.
Where are the data from?
The data's what's from Alpha Analytics.
I understand. What were the monitoring points and who ordered the data?
This was related to the monitoring that was done in Weymouth, I believe. And when we got the information from Alpha for the HIA, it wasn't all the data that they had analyzed, I believe. And so we asked Alpha if they, in the past couple of weeks, if they had any additional data, and this is what they sent to us.
The department's been aware that this hearing has been scheduled since February. And that monitoring data will be issued in this case.
Well, it's not relevant to the plan approval.
What is it relevant to?
It may have been relevant to the HIA, but we have done some initial review of it, and to the best of our knowledge, from our review, it wouldn't change anything to the HIA.
Has that been discussed with Mass Department of Public Health or NCC?
I believe so. Just because we just received it.
We just received it. We wanted to. We have to look at it first to make sure first of all, was what it said it was, and give a brief explanation as to what it contained. We were not aware this was a new process until the data arrived, and so once we became aware of it, as soon as we could make it available to the public, we did. Knowing the petitioners are interested in it, that's why we sent the email last night. We see it as relevant to the HIA process, supplemental data. It's my understanding it's retesting of, or rerunning tests of prior taken tests by Alpha under a different format. So it's nothing, there are no new samples, nothing new in it, but we know the citizens are interested in this, and we wanted to make them aware.
So it's reports that were received by DEP on Monday
Yes.
for sampling that was done when?
During the process, I don't
Prior to January?
Yeah, Mr. Rothschild, I can answer from the one page that I have. The testing samples were July 7, 2018 through July 26, 2018, just on this page.
The department received these on Monday,
Yes.
and they provided it to the parties effectively 9 o'clock. So how do we, I mean, it just strikes me, it's, the department has said it's not going to make a difference, it doesn't impact anything. I don't know that the parties can take your word for that without having an opportunity to analyze what the data show. So I think we're going to.
Well, is it premature at this point to address it before the petitioners have had the opportunity to see if in fact they would do anything with it? And then in the coming days?
It may be, but the point is, what do we do with the equipment? You know, we've got, clearly there are multiple pages that they have not had an opportunity to review, and their experts have not had an opportunity to review. And I think that's prejudicial to them. They need to be able to determine, based on their own expert advice, whether these data make a difference. And they need an opportunity to do that. We're supposed to be completing this hearing today. And we've got a very tight schedule to work on, so I don't know what the expectation is from the department for how the petitioners are going to have an opportunity to review these data, analyze it, discuss it with their expert, determine whether experts need to be recalled in the time. So I see this as a problem, particularly where the department had this on Monday and it's Friday morning on the third day of the hearing. And it's just coming to my attention. And that's a problem.
Presiding Officer, not to suggest this isn't a problem that needs to be resolved. I would like to just ask one clarifying question for the department. The table that was at the top of the information that was posted last night is in form exactly the same as the table that was printed in the HIA for the data for the department collected in July. So the table, as shown in the posted last night, collecting all the data from the 800 pages of laboratory information appears to be identical to the one that
The information in the table is identical?
exactly. It's just table 4, figure 47 from the HIA. It's the exact same format. All the numbers appeared at first glance to be the same. So my
It was
inquiry,
posted in error. That table was posted in error.
the one that's in the
Yes, that first page, that table.
so is the understanding that there are actually different numbers that Alpha has reported for what they analyzed in the document?
So we have a problem. And I'll offer the department an opportunity to get first crack at how we resolve this.
Well, if I may, it was just not a plan. It was not something that council was for us. They wanted to make it available as soon as possible. I wish it could have been quicker. The parameters was not possible to respond to release the data until possible. Having said that, I think why we don't see it relevant directly to this proceeding, I understand the petitioners think it is relevant and it should be given an opportunity to review it. The problem is the time frame, because we are in the fourth deadline with that. If there is an opportunity, we would think that petitioners experts would conclude, as I think we have concluded, that there's no substantial change in the data that already is out there. This was just another, my understanding is another check on another program on the exact same testing that was done before. So it's almost like another year QC. But as additional data, we did not want to keep it from the public. We know people are interested, so we produced it. I think the petitioners do have the right to review it, and if they want to submit testimony on it, I think they deserve a chance to do that. My only problem that we all have is that we have a time frame that we're looking at this that's opposed by the federal court.
Let me address that for a moment, because from reading the court's order, it appears in the order itself that the court did not actually enter the order because the department and the applicant came to an agreement on dates for the issuance of the permit in January and a final decision after appeals in June. And I think the court specifically said, I'm not entering an order, but I'll come back to me if you have problems. So it's not actually a court order. The court made reference to the department and the applicant's agreement, so I think it's a problem that the applicant and the department are now facing with regard to the time frame. And I understand the applicant's concern. Mr. Child, I think you've expressed on a number of occasions your client's lack of interest in extending this process any further. But on the other hand, there is data that the petitioners are entitled to review, and I'm going to give them an opportunity to do that. And the question is, how do we go about that? And I think that the applicant is going to need to take a hard look at that June 28th deadline and determine what you want, are willing to do.
Well, so to report that to my client and discuss it with them. I think that the data is now out there, and I would suggest that the next step should be for all parties to have a chance to look at it and report back to you, today's Friday, within a short number of days as to whether they believe that it is material. If, as Mr. Fallon suggested, it's essentially a different form of QA/QC, and even if it reports slightly different data than what we reported before, that may or may not be relevant. But I think the party should have a few days to look at it and then report to you then what they think is the appropriate course.
I think petitioners.
We certainly need time to review it. The question is what happens with the hearing in the interim.
Well, I think the witnesses who are, I think there are some witnesses scheduled to testify today who can probably proceed because their testimony is not dependent on the date. I think you can probably identify other witnesses that maybe need to be delayed until to determine further after you determine that the data are relevant. Mr. Fallon.
If I'm, just as a suggestion, and we agree with the petitioners, they have a right to review it and a right to cross-examine us on the data and things. But since we do have all the witnesses here, it might be worthwhile to go through the witnesses as originally planned, and then the petitioners can select which witnesses they wish to call back to cross-examine on the data. Just so we have, it just seems that we have the witnesses here, we have a lot of effort, everyone's ready to go. We would have the record more complete, and then we'd have a more narrow focus on just the data for a following hearing, because if we skip witnesses, it's all of their testimony.
I think that makes sense, and I think that every witness, and it's not just the witnesses, the applicant, the DEP's witnesses on the data, the petitioners, experts may need to be recalled And then there would be additional hearing. But I agree, it makes sense to go through everything today, get everybody done, suspend but not close the adjudicatory hearing, and resume on a date after everybody has had an opportunity. I don't know if the applicant has had an opportunity to review these data either. My assumption is you received it at the same time everybody else did. And I would ask the department, Mr. Cushing, I don't know if this came in through your group down in the Southeast Regional Office or if it was provided elsewhere, but everybody in the air permitting group needs to be alerted to the fact that there's an ongoing proceeding, and Monday to Thursday is, in this context, not acceptable. So, why don't we proceed with what we have, and then if the department could give me, Attorney Outman, some sense of the voluminous information that was provided, a sense of what's there. It's 759 pages, is that what you said?
That's right.
Among those seven, I mean, am I correct in presuming that you want to read every page of those 759 pages?
That we're only going to read the even number.
Well, you know, sometimes there's like stuff at the end.
There does not appear to be filler in some of the documents in these proceedings have had a lot of duplication, so within 1,000 pages you're seeing the same language 5 times over. This appears to be a continuous stream of data for 759 pages.
Can I ask the department, is this all of it? Is there anything more?
Not that we know of.
Can you find out?
I think we're fairly sure this is it. There's nothing else.
Okay, I'd like you to be sure. So if someone can make a call, I'd like to know that all the data that are available for this project are provided to all.
And Ms. Rothschild, could we include in that request all the data from Rhode Island as well?
Have those data not been provided?
It has been
That's
provided
been
through
All of-
Mikey, through his
Yes.
testimony.
Okay.
Yes.
And when you're cross-examining DEP witnesses, if you get into that area, you're free to ask. That's all the data.
Thank you.
Okay, so let's negotiate how much time. How much time do you think you need to review all this?
I have not had an opportunity to confer with Dr. Nordgaard and Nathan Phillips about their schedules.
Okay.
That would be the primary limitation on our ability to turn things around.
Okay, are you able to confer with them today?
I can send them an email.
Okay.
I don't believe, I know Dr. Nordgaard's not here, I don't think
I have not seen
Nathan
that.
Phillips is here. But I'll send them an email, I can do it now or at our next break.
Okay.
May I ask one other question?
Of course.
Having looked at their review at the center pages, much of it, as is typical for reports from analytical laboratory, in this case Alpha, are the laboratory QA/QC documentation.
Can you speak up, please?
I'm sorry, the laboratory QA/QC documentation, chain of custody sorts of materials, all of that. The actual results, of course, of which are contained in there. The pages are mostly that kind of lab paperwork, I believe.
Mostly QA/QC,
Is that correct?
chain of custody, things like that. You know, and I don't know either, so
Fair enough.
the petitioners and all the parties will determine. I don't believe the department either had time to go through it unless you have nothing else going on. So,
Certainly acceptable to proceed with the witnesses today and to hold the hearing open pending the ability to review.
and that's what we'll do, but what I need to know, and I think before we go on, I'll ask you to send an email
Sure.
to Dr. Nordgaard and Dr. Phillips, alert them, and over the course of today, you'll get a sense of what, and just let them know that they need to get on the case
Yep.
and not, I'm not looking to delay this. I want the applicant, as much as the petitioners have a right to a hearing on their appeals, the applicant has an equal right to a hearing on its permit. And they're entitled, as are the petitioners in the department, to as prompt a decision on this appeal as possible. And so I'm not looking to delay this proceeding another week, another 2 weeks. I'm looking to get this done to the sweet, as we say. So let them know that if they are available this weekend to go over this, they should make themselves available this weekend to go over that, as I imagine we all are. So I'm not looking to push this on many times.
Thank you.
Okay, you're welcome. We have a lot to do. I think this is an unfortunate turn of events, and I will ask the department to make some diligent efforts to make sure that this is it. From whatever labs receive monitoring data, that this is the end of the universe. Okay? Fair? Okay. So that being said, anyone need a break before we get going?
I'm just sending that email.
Okay. And I believe Mr. Welch is back on for redirect.
In the interests of efficiency, the applicant has decided that